Good morning, Your Honor. I don't have any body cam to prove it, but I am Lauren Brown, Deputy Chief Public Defender. Go ahead and state your name.
Sean Newcomb.
Thank you. Your Honor, we are on the verge of working this matter out. We do need to go ahead and submit a request for drug court, a referral for drug court.
Okay.
Oh, I'm sorry. No. I'm drug court. Yeah. Actually, I'm confused. I need somebody. No. We're going to waive this matter over.
You're going to waive?
I'm looking right at the waiver right now.
Sir, you're going to waive your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir. I'm trying to plead guilty at circuit court and get out of here.
That's too much information.
Bond reduction notes, Your Honor.
Where I got it.
Okay.
So you understand that you will not have that hearing and you'll proceed to circuit court for further resolution?
Absolutely.
All right. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single count.
Thank you, Your Honor. We acknowledge receipt of information. Waivers reading in the record. My client was sending. Actually, I think he needs to sign that waiver. I didn't have to sign it.
Defendant having waived former reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 30th at 1:30.
That's July 30th.
July 30th, 2025, 1:30, Judge Conlon.
Thank you. May we briefly address the issue about?
Yes.
Your Honor, my client's bond is currently set, I believe, at $10,000 cash or surety.
It's 5,000 personal recognizance. Unless he did something.
That got revoked, yeah.
What?
But obviously that was revoked because here he is.
What do you have as his bond?
Your Honor, if you recall, Mr. Newcomb had that incident with the saliva distributed amongst the people.
Yes. Yes, I do recall. Yeah. Go ahead.
Well, Your Honor, that was some time ago. The saliva has dried up, and my client was coming off competency issues. What? He was coming off competency issues.
I got a lot of people that are coming off competency issues that don't spit in my courtroom.
Well, Your Honor,
On people.
he is very truly sorry for that, and he would like the court to know that.
I would like to offer apologies myself, Your Honor. Did not mean it was very, very spur of the moment and reactive. I did not think that through. It was beyond my personal actions that I can really say would be something I would normally do. It was really, really odd for me to have done something like that.
Can we approach really quickly, Your Honor?
Why?
Well, if I say why, then I will need to approach. Approaching things.
I can just say no and it wouldn't matter, right? Yes, you may approach.
Your Honor,
Yes, go ahead.
Okay. So again, he was in court a few months back or several weeks back. He was going through some issues. Again, he's calm. He's much more even keeled. He's not that same guy. And I understand the contempt of court is something that the court takes seriously. I get that. He's ready to apologize and try to repair that aspect of it. What he's asking for the court is to see the person who stands before the court now, not the person who was here weeks ago, not that person, because he's not that person anymore. See the person who stands before the court now and allow him to have a return to a bond. It doesn't have to be a personal bond. We'd be happy if the court would consider $1,000 cash or surety, but he's improved, and we want the court to see that.
At this juncture, what I'm going to do, and I mean, doing what you did that day put a lot of people in jeopardy, inconvenienced a lot of folks. We basically had to have I had to stop court, come in, clean up after you, Attorneys could not use the doorway. Your act, when it happened, clearly was intentional on your part. And bottom line is, I just don't tolerate it ever.
Yes, Your Honor, I completely understand that. And the people's reaction when it happened really floored me, and I realized what I had done immediately after I had done it. I wish I could take it back, and I know I cannot. And all I can do is offer my deepest apologies and pray for.
I am going to deny the request to reduce the defendant's bond at this time or change it. Maybe Judge Conlon, when he sees him, will feel differently, but I do not at this time. So his bond will continue. Thank you.
Thank you, Adam.
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the proper cause.
Yes, Your Honor.
I'll give you a date moment, depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today, along with
I do see you.
my client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at 111 North Adams, Apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But, and I'm
Not candid would be an understatement. I mean, he just outright lied.
well, I wasn't there.
That makes it no less a lie.
I'm asking if you want to hear from him. A humble apology.
I will certainly hear from him, but not if he's going to sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so
So
did you have any O'Doul's?
at first, but
At first. Okay. How many O'Doul's did you have? 6. And then you had how many?
Labatt's about 4.
4.
Sure.
Okay. Now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen
You were trying to tell me what?
nothing. That's what I
No,
told
no, 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 no. Let me tell you what you said, because I remember it very clearly. You told me that you had 6 O'Doul's. I told you to get to the levels that you were, if you were just drinking O'Doul's, because you were insistent on that, you would have had to have a little over a case of O'Doul's. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not. And then you started telling me that you had 2 beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. You remember that?
Treatment. Trying to go to treatment.
Well, okay. Yes.
I'm just trying to.
I don't understand the question.
You said it to me.
He said at the last.
Did you or did you not tell me that you were in treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting, trying to go. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
I really don't.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Doul's, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was going to happen with O'Doul's.
That didn't happen.
Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for me. And then as it got worse, then you ended up going to jail.
Yeah. I get it. Oh, I get it.
So how are you going to get in? You have insurance to cover treatment?
We're working on that. We just changed insurance. So it's not clear about.
His family's here, Your Honor.
They're working
I know
it out.
they're here. But you told me, Mr. Brown, at the bench that he's got insurance that will cover his insurance. And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite. Yes, it will cover some sort of treatment. Yeah.
Anything from the people?
Your Honor, people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person at no point. And we allege that, we're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think without treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concern there.
Anything else, Mr. Brown?
No, Your Honor.
Johnson, here's what I'm going to do. I'm going to first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a scram tether because you were on a sober.
Correct.
You're going to go on a scram tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm going to issue a warrant and I'm going to have him picked up. You understand all of that, sir?
I do.
Thank you.
Thank you, Your Honor.
No, we'll do that. Okay. Thank you, sir.